mewadahi perbincangan yang lebih dalam karena sekali lagi Rawa Gede ini di Belanda sendiri kan merupakan landmark case, dua putusan di dalam 100 tahun sejarah pengadilan Belanda yang bicara soal exception of limitation clause dalam konteks civil suit. Maka kami merasa alangkah baiknya kalau pada kesempatan ini kita mengeksplorasi khusus dengan para lawyer atau legal professionals untuk melihat kira-kira mengapa dia menjadi begitu penting untuk kita diskusikan, apa terobosan yang penting itu, kemudian bagaimana kemungkinan karena ada kedekatan sistem hukum antara sistem hukum Indonesia dan Belanda, maka kami berpikir barangkali ada kemungkinan our destiny cross, the destiny will cross somewhere gitu. Karena kita sama-sama berakar pada sistem hukum yang sama meskipun pengembangannya berbeda. Artinya mungkin Indonesia lebih lambat dari Belanda, tetapi barangkali dengan terobosan yang terjadi di Belanda, kita punya inspirasi untuk melihat kemungkinan peluang-peluang yang tidak bermaksud meng-copy paste atau mentransplant langsung apa yang terjadi di Belanda di Indonesia, tetapi setidaknya menginspirasi beberapa kemungkinan memanfaatkan prosedur hukum sebagai bagian dari upaya untuk mendekatkan keadilan pada pencari keadilan. Nah, untuk itu memang diskusi ini disetting khusus untuk mereka yang terutama litigating lawyers itu atau legal consultant atau mereka yang tertarik untuk menekuni profesi itu. Dan diharapkan diskusinya juga mungkin agak lebih khusus karena itu dibandingkan dengan diskusi yang sudah diadakan sebelumnya yang mungkin audiensnya adalah jurnalis dan general public. Itu pengantar dari saya. Seluruh bahan untuk diskusi ini saya rasa sudah disirkulasikan, termasuk profil singkat dari siapa itu Prof. Liesbeth dan bagaimana geraknya dalam upaya mendorong pencarian keadilan melalui penggunaan prosedur formal hukum. Nah, tidak berpanjang saya akan memberikan waktu kepada Prof. Liesbeth untuk memulai sedikit membahas mengenai hal-hal khusus yang penting untuk kita diskusikan dalam konteks decision dari pengadilan terkait kasus Rawa Gede ini. Waktu kami persilakan.
Also to make it a bit less formal, I mean I'm here, you're there, but I think we can get much further if we would all be more less opposite to each other. But nevertheless, I didn't really prepare any presentation, and I didn't know who of you were present at the meeting on Thursday. The public meeting where we already discussed the details of the case. Were all of you present at that meeting? No? So for some of you it's the first time to discuss the case. Okay. Is there a translation of the case into Indonesian? You have a copy in what language?
English.
Indonesian? English. And it's a full court ruling, or is it a summary? Okay, okay. I mean, to discuss the ruling in full would take a lot of time. I think we have roughly an hour, maybe a bit more. So, and I may be speaking about things that are not particularly interesting to you, because the purpose of this meeting is that it also gives you an opportunity to make a comparison between the Dutch case and potential cases here, which for me is very difficult to envisage what the problems may be here, and then to explain how we dealt with these problems in the Netherlands. So I would think that it may be more useful to start on the basis of points that interest you particularly, and then to follow up on that rather than me giving a presentation of what we actually did. I can say a few things just to kick off. Also, I mean, it's a landmark ruling, but also for us. And I heard the chair saying that we may be a bit faster than you are, but I mean, this is 64 years after, and I wouldn't call that really fast. And it's only because Jeffrey Ponda and the KUKB Foundation took the initiative that we actually got going. I mean, there's nothing like we're faster or slower, it's just someone has to stand up and push through. And then you must be lucky with the judges, because another composition of the bench may have resulted in a completely different outcome. So there's, I wouldn't say it's totally luck, but there's a combination of factors that in the end have culminated in this result, which you cannot predict when you begin. And we start, actually as a law firm, we start many cases on human rights matters that are much less successful, or take a decade to land in a positive result. So it's more the principle and the belief that justice should be done that we believe the law is in our favor. In this case, I predicted that we would lose it, and I warned, well, in the beginning I wasn't even prepared to start the case. I said I will approach the state, I'll write a letter to the state, and tell them that they're responsible and that we should settle this case, because this is not a court case, this should be dealt with in a different way. And they were open to discussing the case, they were open to kind of solutions short of recognition of their responsibility. So they paid, when we started the case, they paid 850,000 euros in development aid to the village, which was meant as a gesture towards the villagers, but it wasn't a recognition of responsibility. And we proposed that they should then dedicate the money, the development aid, to the murders back in '47, and that may then be sufficient for us, and we would drop the case if they would be prepared to make a link between the humanitarian program and the responsibility for the crimes. But they refused. Also, they presented us a criminal file dated '47. Criminal file that contained an exchange of letters between the prosecutors at the time, discussing whether the commander who was responsible for the murders should be prosecuted or not. Ultimately, of course, we know that the decision was that they were not prosecuted, they should not be prosecuted, but the exchange of arguments was very interesting for us to read, to see how they viewed crimes at the time. And it turned out also for the court to be a very important file, because it gave the court an understanding of how these crimes were viewed at the time, whether they were to prevent that they were ruling with contemporary norms, an old crime, which may at the time have been viewed completely different. They wanted to prevent, you know, today's understanding of human rights, to apply these understandings to an old crime, and then, well, I think they felt that it wouldn't do justice to the people who were responsible for the crimes at the time. But the criminal file contained evidence for them that also at the time these were considered serious crimes, because it was written down that if the commander would be prosecuted, he would no doubt be convicted for manslaughter and would go to jail for a long time. And so the court said, well, apparently our understanding of these crimes is similar to the understanding at the time. The understanding that you shouldn't kill your own citizens. So these were the steps that were taken by the states before we started the case in order to, well, let's say, approach to reach out to the people, but all short of acknowledging responsibility. And so we started the lawsuit, and we were told, of course, by everyone surrounding us, but also by the state lawyer, that we would no doubt lose the case because there's statute of limitations, which are 5 years or at most 30 years. So at best, the case would become time barred in 1977. And so we were starting a case that we were about to lose. That's what I told the clients. We started for principal reason. It has to be done. Even if you lose, you're still the winner. I mean, let the state invoke these time bars, because it's not something, time bars are not applied by the court on its own initiative. It has to be invoked by the other party. If they drop it, if they don't invoke it, for whatever reason, they will not be applied. So it's the decision of the state first to be made to invoke the time bars, and then it will be assessed by the court. And I felt, let them invoke these rules. Let them make themselves also a bit, ashamed to do such a thing in the face of these victims. And with all the press around us, because by the time we were well aware that the media and actually the people of the Netherlands and the people worldwide were on our side. So it would be an interesting battle to see them make very formalistic arguments versus a complete community saying, questioning their legalistic attitude. And also when the ruling came on 14th September, and I said, well, we'll lose, but we will win anyway. I mean, I was preparing my comments for the media because the whole courtroom was full of media, and I was thinking, okay, what I'm going to say, we're losing, and I was drafting some words for myself, what my response would be, and I drafted, we are winners. I mean, the rights, justice on our side. And the court, really couldn't rule differently in view of the statute of limitations. But it turned out to be to have a different result. And the court says that it was unfair and unreasonable to invoke the time bars. So they discarded, they rejected the invoking by the state of the time bars, which was not expected at all. And also the state lawyer was flabbergasted, literally. He sank under the table when the court continued. In the end, he only saw his forehead. It was quite amazing. So it's not something that we do on a regular basis. These cases in Dutch courts, as a firm, we do these on a regular basis, but winning these cases is not so common, and normally they take much longer time. This is a ruling that was delivered in the first instance. No appeal. No Supreme Court, no European Court of Human Rights. It stopped after the district court's ruling, apparently considered by the state either to be an opening to say sorry, to stop the case, to take the opportunity to do something about it on a more limited scale, because of course the question of apologies had been raised long time ago and on very different occasions, and now they got the opportunity to say sorry to a small group of people for a limited number of events. So, in a way, I feel also they were assisted, they were pushed in a supportive way to do what they may want to do, but they didn't see the road how to do it. It was not a fluke case that came to them, it was just this limited event. So that's about the case. I must also say that we presented many more claims than only the claim, the tort claim for killing villagers. We also presented a claim for not prosecuting the perpetrators, which can be a tort in itself. There's a duty on the states to prosecute crimes that have been committed under its jurisdiction. It's a duty that's contained in all human rights conventions. And you can either file a complaint to the prosecutor and say, hey, you should prosecute. That was one road we could follow, but then you're fully dependent on the prosecutor. You give the case out of your hands. You can also present a civil claim that says they haven't prosecuted and that create damages to the people because they are entitled to a prosecution. And that's then a civil claim in a civil court, and you're in charge yourself. It's a private lawsuit between two parties, and the court is more at a distance ruling on the case, but not really having a say in how the procedures are being conducted. That part of the case we lost. Actually, all other claims we presented were considered to be time barred. That was the criminal part. They didn't go into the question whether the state had failed to prosecute, whether there was a duty to prosecute, or whether they hadn't done so. They just said whatever we find of this claim, it's time barred. Also the claim on behalf of the children of the widows, those widows that had passed away. For one of them we filed a claim on behalf of a child. And the court said only those people who had personally experienced the murders have been done great injustice, and they are to benefit from an exception to the time bars, but only these people. So only the widows and the surviving males of the crimes were awarded damages. And any other category of person, any future generation, they were cut off. Also, we filed a complaint on behalf of the foundation, Jeffrey Conrad's foundation. The foundation can litigate in the Netherlands, and they are not representing anyone, but they are basically litigating in the interest of all others, anonymous persons who have also been affected by the crimes. And it's meant to prevent numerous lawsuits in large-scale cases, for example, particularly environmental cases, climate change cases, cases where the number of affected people may surpass the hundreds. And the foundation that represent these interests, who are established with a specific statutory goal to defend these interests, can also litigate, not on behalf of a specific person, but on behalf of an anonymous group of interested individuals. And so, legally speaking, the foundation could file a claim here, representing all the others, the children, the widows that did not present in court, and it was unlikely that there were many others. And the foundation, the court said, was only established in 2005. The crimes were committed in 1947, so an exception to the statutory limitation rule is not acceptable. It's a step too far for such a huge exception to be made towards a foundation that hasn't suffered personally, that hasn't suffered as a human being, which was the red line for the court to explain its decision to accept an exception. And as this foundation is not a human person, you couldn't really say that it had suffered. So we suffered losses as well. I told the ambassador yesterday that we lost on a number of aspects, and we also decided not to appeal. I said immediately after the ruling we will not appeal if the state doesn't appeal, and I called to the state not to appeal for humanitarian purposes because the widows are likely to pass away soon. I've just accepted this court decision, and that's separate. And they took that to heart apparently, and we also decided not to appeal for example, for the children who lost. Another lawyer may have said, well, we lose on these aspects and we appeal all the others, but in my view it's not strategically not wise to go to the very end, to push the ceiling more and more. I think it's also a kind of an understanding with the defendants what we are after, and the settlement, really a settlement, and closes this chapter. So for me, another lawyer may pick this thing up, and Jeffrey may decide to approach a different lawyer, but for us this chapter is now closed in our dealings with the state. I think maybe a final thing I want to add is this case would not be possible without the foundation, and it's not to celebrate Jeffrey here the whole time. But the point is that for us, for example, it was not possible to speak with the widows because they couldn't read, they couldn't write. I couldn't talk to them in their own language. They don't have a telephone. I couldn't call them. At no point I was in touch with them directly. The biggest problem we experienced with doing this case, and this may be less of a problem for you because if you do cases on behalf of your own citizens here or your fellow citizens, you may of course be able to talk to them. But still they may be on different islands. There may still be a problem of contact and communication. For us it was crucial that there was a foundation that I could trust, that I knew that wasn't after the money, that wasn't after its own interest, but that was really representing these people. And I could trust that if they would tell me something, and they would pass on papers and return papers with signatures, well actually thumb stamps, that this was the say of these people, this was what they wanted to communicate. And that at some point I wouldn't find out that either, let's say, the compensation amount has disappeared, or that people would have been deliberately left out, or that actually the children were speaking on behalf of parents, or a local foundation that had a completely different interest than this human rights court. I mean, that would be a disaster on all levels. It would be a disaster for any future human rights cases in courts. It would be a huge media disaster that people would be exposed as, you know, actually being used for other interests, for larger groups than for other profits. So I'm working for Kenyan victims, I'm working for Iraqi victims, I'm working for Afghan victims, and the trouble we experienced the whole time is what do the people actually want, and how do you actually know what they want? So that's something and it's crucial, it's really crucial that you speak on behalf of these people and on behalf of no one else. That's maybe I want to say by way of introduction. What about translation? Sorry for that.
Saya hanya ingin menanyakan saja apakah perlu diterjemahkan lagi atau sudah bisa dipahami. Nanti penerjemahannya hanya misalnya kalau merasa hesitant untuk ngomong langsung dalam bahasa Inggris bisa bertanya dalam bahasa Indonesia, nanti diterjemahkan seandainya dimungkinkan untuk dan memang tidak ada masalah dengan bahasa, supaya kita bisa mempersingkat waktu dan memadatkan waktu supaya diskusinya lebih lancar. Tapi kalau dirasakan ada, please tolong bilang, jadi nanti kita akan terjemahkan aja semuanya gitu. Karena sekali lagi consecutive translation pasti akan memakan waktu 2 kali lebih banyak. Hanya ini aja sih konsepnya. Kalau tidak, maksud saya kita bisa mulai interaktif. Itu bagian dari introductions yang diberikan terkait dengan kasus dan beberapa elemen-elemen mendasar penting yang termasuk batas daluarsa dan seterusnya, termasuk soal terakhir bagaimana merepresentasikan privilege dan hambatan yang terkait dengan itu yang dialami baik di kasus ini ataupun berdasarkan pengalaman-pengalaman dari kasus-kasus yang lain yang tadi disebut ada Afgan dan seterusnya. Saya mengundang teman-teman karena ini diskusinya kan agak audiensnya sangat terbatas. Saya berharap waktunya bisa dimanfaatkan dengan maksimal sehingga kita betul-betul bisa apa yang teman-teman sungguh ingin lontarkan. Saya yakin Pak Fadila sudah menunggu sejak hari apa untuk bisa berinteraksi dengan Ibu Liesbeth. Jadi saya sungguh mengundang teman-teman untuk mengungkapkan seluruh entah pikiran, gagasan, pertanyaan, keinginan tawan yang muncul ketika mengetahui baik Ibu Liesbeth ataupun kasus Rawa Gede itu sendiri. Terima kasih. Kami persilahkan.
Kalau bisa sambil memperkenalkan diri supaya ada interaksi yang lebih dekat. name is Fadila Agus. I'm very happy that I finally could meet you because I used your book quite intensively for my dissertation. I could meet you when I was in Utrecht. I met with Professor Thierry. So this is very interesting case for me as a practicing lawyer as well in Indonesia. First, maybe I'm wrong. So in this case, there is no crimes, there is no court decisions regarding the crimes that have been committed during that period. Is that right?
What do you mean? There's no court decision?
I mean, there is a exchange of letter between the Prosecutor General Office and the Minister of Justice. And in one of the court, it said that therefore I do not consider further investigation appropriate. This is the response from the Minister of Justice.
Is that the court ruling you're citing from?
Yes.
Which paragraph?
Paragraph 2.15.
That's the...
A letter.
Oh, that's a letter.
That's a letter.
Yeah. Yeah. We determined the prosecution of crime request no longer possible. That was the discussion in 68.
Yeah.
The decision should be ruled, should be read as follows: that it always first describes the facts, and then that's paragraph 2, all the facts that were used by the court to base its ruling on, and then paragraph 3 is the positions of both parties, and 4 is the judgment. It's very simple. So the really crucial paragraphs are to be found in paragraph 410 to 420. And paragraph 2 lists the relevant facts. This is there were a few sources the court based itself on, and that was the exchange, that is paragraph 2.7, between the prosecutors and the commanders in the 47. And it says, I hereby forward to you a file about the Kawam event. It concerns the matters of execution by the major. I'm rather worried about this. The man is liable under criminal law, and if tried by court-martial, he will irrevocably be convicted, which will cost him his further career. That is how it was described at the time in an exchange of letters between the criminal parties. The other source the court uses, what you refer to 11, which is the what we call the accession nota, report drafted by the state in the 60s, pursuant to a military that suddenly start to speak out about the atrocities, and it's really steered up the emotion and the debate in the Netherlands, and it's forced the state to investigate the crimes. And this is a phrase from that report that resulted from this investigation. Well, that was not your question, perhaps.
Yeah. So my point is, even that there was no court decision regarding the crimes that have been committed, is only indication from the exchange of letter. So you still can still go to the ask for the compensation.
There was no dispute about the facts.
Yeah, no dispute about the facts. So
the state didn't challenge anything.
The state they agreed with the facts, even there is no court decision on that facts. So based on these facts, and then the court is ruled case for you.
Yeah, you don't need a criminal conviction to start a civil litigation. You can just gather your own facts.
Yeah.
And this was one of the criminal file was part of our facts we presented, but even without it, we may have been able to succeed in this case. You gather facts through witnesses. There was a UN report that's called "The Murders Deliberate and Ruthless," and we had the accession nota. And the state just didn't deny any of these facts. So we started with a full agreement on what actually happened, which is exceptional, of course, in a litigation.
So this is very important because in the Indonesian system, we should be a proof from the court that the criminal act is committed, and then the civil case can be proceeded. That's compensation according to the criminal court or human rights court in Indonesian, under Indonesian law. And also I would like to have your opinion, because this is the same case with the Exxon Mobil case between some Achievers that asked compensation to the Exxon Mobil in the US court. And the court ruled that to pending the case, because there is no evidence of human rights violation in Aceh. So the court is pending the case because they wait for evidence from the court, from the Indonesia court, whether there is a human rights violation or not in Aceh at that time. So I would like to have your opinion, because this is very different approach between the Netherlands court and the US court system.
Well, I think our systems are quite similar, and also in our country you can ask for compensation when a crime has been established, and then the compensation is directly linked to a criminal case. But you can also, of course, and I guess it would be possible here as well, to bring an ordinary tort claim. So you rephrase human rights violation just like a personal injury case. It's just a tort case. Anyone who damages someone else's rights is liable to pay compensation. Full stop. And there's no human rights reference in this tort article. There's no crime reference to any crimes. It's just an ordinary tort, just like you have an accident in the street between two cars, and you pay compensation for the damages. That's it. And also human rights abuses can be fit under this heading. That's how we did it. And the reference to crimes here is, you can even say, it's just accessory. It's not. I mean, it was part of it, but it wasn't even necessary perhaps. You could have used other source, and then there was no reference to any criminal case whatsoever. So you shouldn't see that as a necessary link, and maybe also not within your system. It may, well, if you want to, of course, if you follow a criminal lawsuit, you could ask for compensation on that basis. But short of a criminal lawsuit, it may be possible to follow this road.
Yeah. So that's the thing, because we have there is no this kind of case in Indonesia yet, but we can give maybe as a lesson learned from Indonesia to bring the facts and then to the court without any criminal case based on the criminal case, and then ask the court to pay a compensation. Because according to the human rights court, because on serious crimes, for example, here in this under the system of human rights court, the court will only decide about the compensation if there is a human rights violation committed. So in this system, human rights court system, but I never.
Maybe you should go to an ordinary civil.
Yeah, maybe.
Just think of a different route. I mean, we based ourselves on the torts rule that exists, at least at the time. It was exactly similar under local law here, but also under Indonesian law currently, today, because we investigated the applicable Indonesian law, because there was a debate on the applicable law, whether it should be the colonial system or the Dutch system today or the Indonesian system today. And just to prevent that we were presented with a surprise, we looked into the Indonesian law. And it's exactly similar. The rule that we use, that if someone damages someone else's right, he's liable to pay compensation, is exactly similar in your system. It's there. And that's what we invoked. And we don't have a human rights court, we just have civil courts, criminal courts, and administrative courts. That's it. And so we rephrase all kinds of serious issues under the ordinary tort system. And we say, well, if you order someone to pay the damages for a car crash, why not for such a serious matter? We try to, as soon as you phrase it as human rights concerns and if we go to human rights court, I'm also a bit afraid that it gets politicized too much. We try to keep it, though we, according to the way, not very successful, but we try to keep it low profile. This is not a big deal. We're not going to discuss the Independence Day of Indonesia here, because that was the interest of my neighbour that we would insert many other aspects in this case. We said, no, just only these killings, very sec, pure law application. That's it. Nothing more, nothing less. Not a big deal. Not a human rights matter, although in the end it was of course a human rights matter.
So when we register this case to the court, under what register system? Because here in Indonesia, when we register the case and the registrar asks, this is what case that you are going to register, criminal case or civil case?
Civil, yeah. Yeah, civil.
Civil case.
Yeah, because you sue someone.
Yeah.
There's no prosecutor. Yeah.
And then it's not normal for Indonesia. In a civil case, ask for compensation based on the criminal facts.
Yeah, but it's not criminal facts only. It's
Yeah.
also civil facts. I mean, someone hurt someone else, it's a civil matter. Also, there might be a criminal aspect in it, but it's definitely also civil. It's very normal to distinguish between these two. And the criminal matters for the prosecutor, it's out of your hands. But you can take the initiative in your own hands by suing the defendants. Those are responsible. If they have the money to pay, the state has. I mean, the Indonesian president was sued when he was allowed to travel to the Netherlands for crimes committed on the and he decided not to leave even in this country. And that was a civil lawsuit as well, an injunction procedure. There was no criminal aspect there. And so our government tried to convince your president, saying you can easily leave, because there's no prosecutor, no arrest. But it wasn't very well understood here that it wasn't a criminal case, it was a civil case, and the civil court can never arrest someone. It's about compensation, it's about a monetary award. No arrest. It's just payment. So the government, it was interesting, there was an interview with the people from Foreign Affairs, and they said, well, we did our best, that there was no risk. But apparently it's easily been drawn into the criminal area here.
What might be interesting as well is from this flow of discussions to see the possibility whether other lawyers, whether it is possible within the legal system, because the court then ruled that there should be a compensation paid, implied that the court also actually recognized the crimes occurred in those events, so it gave a good foundation to deliver compensation, particularly the charge on the obligation to the compensation of the victims. I was just wondering, because Fabiola asking about the possibility, the different possibility, right? Starting from criminal recognition by decision of the court, the crime was committed, and then follow it up with the civil suit. In this case, this is the civil suit. I was just wondering if there is any possibility for lawyers, other lawyers, of course not your law firm, to move forward into criminal procedures using this decision as the foundations to ask for the obligation of state, although you said that the state is deciding not to do this and that based on certain political consensus.
Yeah.
But this is a court ruling just recently issued, and it's effective in a way. And I was just wondering whether there's any possibility for other lawyers to move forward into those sort of criminal prosecutions.
Oh, we considered filing a criminal complaint several times, and one of the reporters that's actually joining us in this trip, hello, your daughters, identified a perpetrator of these crimes, a man that admitted to have killed 120 of these men in Rawa Gede. And he was interviewed and it was broadcasted a few weeks ago. And so we presented it to the prosecutor, the reporter presented it to the prosecutor and said, hey, I said in the interview, in the television program, I said the prosecutor should act because here's one of the perpetrators, and why not prosecute this man? Because we're prosecuting all kind of Germans that have killed Jews, but we let this man go because apparently he's of nationality, and we feel this is less important. And so the prosecutor responded and said, well, the widow should then file a complaint, and then we may act. In the meantime, last week the man passed away, the perpetrator, and so we now lack a clear target. There are many other killers still alive, but if there is, it may be considered that a criminal complaint is filed. We asked the widows yesterday, they don't want to. They don't want a personal retaliation against individuals and say this is okay this way, we just don't want to pursue this. And without clear clients, apart from the foundation, it's a bit difficult. I mean, I'm not acting out of my own initiative. I represent people. But it's also important to realize that this court cannot establish crimes. There's still a misunderstanding that, and I think it's because the word crimes is used every now and then, because there are some sources that refer to crimes that are used by the court, but a civil court can never establish a crime. It can establish a tort. So with this in your hands, it's never enough for a criminal conviction. Because, for example, for one thing, the threshold of evidence that's required for a civil complaint is much lower than for a criminal conviction. So the crime reference should not be mistaken as a position that crimes have been committed. What the court said, torts, wrongful acts have been committed. That's it. Nothing less, nothing more. The other way around, if we would have had a criminal court convicting this Mr. what's he called? Bauman?
No. Oh, yeah.
Bauman, who committed the crimes and he would have been convicted, that would have been a binding ruling in the civil court. So on the basis of that criminal procedure, you could start a civil tort action. And the law says any criminal conviction is binding for a civil court. Because the threshold of evidence for a criminal court is much higher, so it is always sufficient for a civil ruling, but not the other way around. So yes, it could be done. I think if there's a perpetrator identified, we may consider it, because it kind of feels a bit awkward to have people in the Netherlands responsible for so many killings. Just, living freely then.
Maar we kunnen dat dan doen.
Als je moet zeggen, ja.
Maar dat is niet zeggen.
Ja.
Zeg maar dat we ongeveer zijn.
Ja, zeker.
Kita sedang mempertimbangkan akan melakukan gugatan mengenai yang tadi bicara atas nama yayasan Prof.
Karena begini, because according to the according to the Hague Convention, the state should be responsible for any wrongful act committed by the state actors during the wartime. So based on that, and because the crimes is recognized by this court ruling, meaning that their criminal acts is occurred, and if I'm not mistaken, there is Stadler numbers, I don't know, on the 47 in Indonesia regarding war crimes. So on the basis of that Stadler, and also on the basis of the Hague Convention number 4, and then we can go to the claim.
Yeah.
That's even the perpetrator has passed away, but the state still has responsible.
But that's the point.
Yeah.
But then I wouldn't use the Hague Convention, I would just use your own tort law.
Yeah.
Because the Hague Convention, I mean, if you're unlucky, Japan has ruled, the Japanese High Court, the Hague Convention only applies between states.
Yeah.
And as an individual, you have no standing to invoke it. So I would be careful. I mean, maybe I'm wrong. It's not possible to use the civil law statutes, but that would be a means to circumvent the interstate rules. The only interstate rules that you can safely use, in my view, are the human rights rules. And humanitarian law is not very friendly towards individuals. That's a bit of a problem. But is there, for East Timor, for example, has there not been paid any compensation for victims?
No, there's a friendship reconciliation and friendship commission. So reconciliation and friendship. They reconcile and then they found there are something that happened, but then they are not eager to go to further attack.
But if a burglar enters your house and steals your property, your personal belongings,
Yeah.
I guess will be obliged to pay for the things he has taken away. Normally, I mean, compensation amounts are awarded in Indonesian courts, I can imagine. But no one has ever. And then, if a man tortures his wife in the household, would he be obliged to pay for the violation of her rights?
There is important interesting also because this, if for example for this Timor case, if it's the victim is Indonesian, should he or she register the case to the Timor-Leste court or to the Indonesian court? In this case, for example, your clients, are they Indonesian citizens or you consider them as the Netherlands citizen at that time?
Well, I didn't consider them anything, but I just didn't want to open the debate on the independence of Indonesia in 1947, because we were bound to lose if we would enter such huge political questions. So we just left it for what it was, and then, I mean, our system takes it for granted the Dutch law or the colonial law still applied in 1947, that was still a colony. And the colony belongs to the mother country, so then it would be Dutch citizens. So, I mean, it's not a political finding that I agree with, but for, just to start from some common understanding, and then you can really debate the real issue rather than kind of. But what about mistreatment of people in households? What would that lead to compensation? If that would happen in Jakarta today, someone beat someone up in his own house, and he would go to court. Would he then be ordered to pay damages?
Yeah, we can do a civil suit in parallel with the criminal procedures.
But only in parallel with criminal procedures. You can go to court and say, well, he damages my rights.
The tort system is not really working in the Indonesian legal system.
Because you can't work for 3 weeks anymore because you're suffering, and so you suffer loss of income. Like they say $10 for a week, and you want to have that money from the person who has beaten you up. It's very basic.
But not very popular maybe, but
Well, it's the same approach we followed here. You beat someone up, actually you kill him, and you pay. So that's it. It can be an ordinary murder in the night. It can be 150 persons, it can even be 400 persons.
So, I have two questions. Sorry, I actually collected everything. The first one regarding the evidence, because yesterday you told the discussion with the three main evidence, and one of the evidence actually you received from the Dutch government, which is the correspondence between the Pengadilan and the lawyers. So hypothetically, if there is no goodwill from the Dutch government to share some information, would you envision to have more difficulties in dealing with this case? That's the first question. Second, how important is media attention for this? And third, have you ever done similar approach, like use the very basic concept of civil lawsuit to deal with other types of atrocities of major human rights violations? Actually, I have four. Please to know.
Yeah. Okay. The sources. The second question was. Oh, you mean, yeah. Well, the criminal file. Well, the courts cited from the criminal file that we got, so I can't say it wasn't important. I'm not sure that without it we wouldn't be able to bring this case, especially since the states choose not to deny or to dispute the facts. So we were in a rare situation that we had fully agreed on everything, except for the statute of limitation. So I'm not sure, but a lack of facts is often, I think it's the biggest problem we face in these kind of cases. these cases turn around facts for 90%. Without facts, you have no case. So if you lack the facts, or the state is sitting on the facts, which is of course, in the majority of cases the situation, you're just left behind and say, well, I need something, you better give it to me. Well, we have under Dutch procedural law, you may have it as well, disclosure procedures. So you order the case, the state in a separate procedure to disclose the sources they have. And that's a procedure that's often followed. You can even ask a prosecutor, if you envisage to bring a civil claim and you are aware that there's either a related criminal case or a criminal case that covers exactly the same fact, you can order the prosecutor to disclose his file to you, for the benefit of individual rights. So that's that would then be the answer to the shortage of facts. The other answer would be, and that's what the only situation we use criminal procedures to serve our clients is when we lack facts. We then go to the prosecutor and say, hey, it's your duty to investigate this. And so we transfer our investigation to the prosecutor and he should do his job. With a great risk, of course, is the prosecutor is not on our side and he refuses to do so. And then we go to court and we say, hey, you have to order the prosecutor to do his duty and to start a criminal investigation. It's a special procedure where the prosecutor falls under the court's responsibility, kind of checks and balances system. But we have a few cases where, for example, we did sue. We're working for Palestinian citizens that live around the wall between Israel and Palestine. The security fence is called by Israel, and the Dutch company is actually providing cranes and other equipment to construct the wall. And we filed a complaint to the prosecutor saying that the wall is criminally liable for war crimes because the wall is illegal based on the decision of the International Court of Justice. And we said, well, actually it's also a crime and our company is contributing to it. There's not too much evidence, and I knew that the prosecutor was on our side, so we filed a complaint, and the prosecutor is now working on this for 2 years already, and they are to decide later this year. And I'm hopeful for a positive position and that actually court case and criminal suit will start against the company. We're considering their civil lawsuit, but there's a shortage of facts. There's also a shortage of money because these civil lawsuits are extremely costly. And the foundation that wants to bring this, the ICJ, the International Commission of Jurists, wants to bring such lawsuits, lacks the funding to litigate for decades or so. So these are strategy considerations to choose between one or the other possibilities, but shortage of facts is generally a huge problem. Media attention is, I believe, is crucial because it increases the pressure on the courts. The room left for them to do away with such a case on very, on kind of technical basis. Just not to take it seriously. I mean, we also are just a court with human beings, judges, and some have this opinion, some are linked to that political party. I mean, you have all sorts, all colours. And you want to try to move them in our direction. And if you start early on with media attention with a certain flavour, and they read it, of course you're influenced. I mean, they'll say they'll never, weigh their decision because they are not allowed to. They are to take the decision, to make the decision purely and only on the basis of the file represented. It's only on the basis of the arguments of the parties that they can decide. But if they are citizens, they read the newspaper and they watch television, so in a way the more the better. Provided that it's good attention and not negative attention. And we are kind of happy enough to get a lot of media attention. judge will have maybe 2 weeks, 3 weeks to consider the claim you're presenting, and they have a lot of other work to do, and so to really grasp what you're presenting in a short period of time, it helps if you have a longer, longer period in which the opportunity to convince people. In 5 minutes it's more difficult than in 10 minutes, and in 15 minutes, and in 3 weeks. So if it takes some years with the same arguments being made over and over again, at some point they start to realize that there's... Ja.
Jadi selain apa yang Ibu Zegveld tadi cerita, itu sejarah antara Indonesia dan Belanda itu sangat sensitif sampai sekarang. Jadi itu kalau mengenai Indonesia atau juga masuk di koran itu banyak orang yang membacanya dan ada itunya, ada apa? Ya.
Kalau dari Sabangka sendiri melakukan strategi media untuk
Saya sih lobby. Saya tetap lobby dengan media, dengan Parlemen Belanda, tetap lobby itu. Jadi di samping melalui media, koran, televisi, saya masuk ke parlemen, bicara dengan partai-partai sebanyak mungkin. Cuman PVV enggak ya, Anda tahu ya, partainya Wilders, saya enggak bicara sama mereka. Yang jelasnya partai-partai yang wajar lah. Biar gimana pun juga itu akan dibicarakan di dalam parlemen. Parlemen itu bicarakan dengan menterinya. Menterinya bicarakan dengan perdana menterinya. Pasti itu. Biarpun sedikit, tapi masuk. Tapi itu perlu itu. Dan sebagus-bagusnya juga kami mendapat dukungan dari masyarakat Belanda juga. Enggak semua. Karena saya dengar tadi beliau mendapat email dari orang-orang Belanda itu yang sebetulnya nggak enak, bahwa mereka tuh nggak setuju bahwa mereka mendapat ganti rugi. Karena menurut mereka justru Indonesia yang harus karena kejahatan Indonesia kepada mereka itu di zaman bersiap. Gitu. Jadi sekali lagi itu sangat sensitif masalah Indonesia sama Indonesia sampai sekarang sama Belanda.
Kalau begitu apakah bisa dikatakan sebenarnya kasus ini sendiri samping seluruh argumen yang diberikan bahwa sebenarnya dia mencoba mengikuti prosedur hukum yang lebih ordinary dibandingkan yang lebih spesial gitu, coba quote-in. Atau kemarin kan ada pertanyaan soal ternyata ini bukan exercising universal jurisdiction misalnya, tapi dia betul-betul lebih memilih ke prosedur hukum normal biasa yang logikanya secara sederhana dijelaskan sama Bu tadi. Nah, kalau melihat itu berarti apakah dan melihat keterangan Bapak, apakah salah satu yang membuat kasus ini menjadi sangat khusus itu adalah fakta bahwa kasus ini secara politis itu sangat sensitif.
Oh iya, jelas itu, jelas. Biar gimana pun juga itu pendapat saya ya, nggak tahu pendapat beliau. Pendapat saya itu jelas itu. Kan beliau melihatnya dalam hukum. Kalau saya melihat melalui kritik dan sosial. Bagaimana tuh orang-orang di Belanda tuh mengasih pendapat.
Ada pertanyaan ternyata Pak Lukas.
there has been one exception before to the limitation period that was accepted by the court, and that concerned victims who inhaled asbest in their earlier life and then found out about their illness and their likely death in the near future after 20-30 years. By that time, the time that expired between the wrongful act, which is the starting time for the expiration period, and their discovery of their illness had passed, gone beyond 30 years, and so that any time bars would then be applicable. And there, in a long, protracted procedure that ultimately was decided by the Supreme Court, the Supreme Court said it was unfair to confront individuals with time limitations when they weren't even aware of the wrongful conduct, namely the exposure by their employer with asbest at the time. And it opened, it paved the road for future cases in the sense that they drafted, the Supreme Court on that occasion, it was in 2004, drafted a checklist of criteria that should be applied by the courts in the future to examine whether an exception to time bars would be acceptable. And these were A to G, so there was about 6 or 7 criteria that should be applied. And looking at these criteria, we have quite a favorable case because basically all the criteria, the answer to all the criteria was in our, confirmed our claim, except for one. What these criteria were, just to give you a few, and we discussed these criteria extensively in our pleadings, of course, being preceded by a long discussion whether they were applicable at all, because the state also felt that there were some problem with these criteria in view of this case, because actually they applied. So he starts off by saying they're not applicable because it is a new law, and we're discussing crimes, I shouldn't say crime, we're discussing wrongful acts in 47, and these criteria from 2004 weren't relevant at the time. So first we had a long discussion of old law and new law, and transition rules from one system to the others, and the court ruling on 14 September, the introduction by the court started which law, when the criteria actually applies, and then at the end it's saying, well, actually they do apply, and the old law should incorporate these criteria. That was a technical debate. It was quite difficult. But then discussing these criteria, these were, for example, are we speaking of serious offences that really affected human beings? Well, the answer was, of course, yes. To what extent is evidence still available? Because the main reason for time bars to be applied are that it's not fair to confront the defendant with a case he can't defend himself against anymore, because he lacks any remembrance or any details, any evidence to present to court in his favour. So time bars are meant to enable the court to say at some point the case is finished, the case is over, it's too long ago, you can't debate something that has happened such a long time ago, because everyone has forgotten. The people out there died, the evidence has evaporated and so on. But that was interestingly enough, I mean, that didn't apply to our case, because all the evidence was there. Actually, there was no disagreement on the facts. So that was a huge point in our favour. Then there's a criteria, is the defendant insured against the damages that may be awarded on the basis of this wrongful act. It's not fair to that someone goes bankrupt on the basis of a very old case, which he thought, which he anticipated he would never be liable anymore for to pay damages, so he didn't take care of any savings or any insurance. Because insurance, I mean, it normally doesn't cover facts happening. It's happened a long time ago. Well, the state doesn't, as a matter of policy, doesn't tend to insure itself against wrongful acts, so that didn't apply. A few more criteria, but then the more difficult one for us was why haven't the plaintiffs not shown up earlier? Why did they wait for such a long time? And we engaged experts, anthropologists on Indonesian social circumstances, on Indonesia generally, who work here, who are both Dutch, and they're Dutch, but they work here also here in universities, who could report on the question whether these widows didn't act at all, basically, because I said they wouldn't have acted now either. It was because of them. And so they drafted reports supported by 2, 3, 4 professors, all saying, distinguishing between different periods, saying, well, Indonesia between 47 and 53, forget about any legal action. Then 53 to 65, these villages were too far from any, there wasn't a legal aid system, there wasn't money, they couldn't read, they were kept away from any legal initiative. At 65, a new period started in Indonesia with the communism, anti-communism coup, disrupting the entire society here, and again prohibiting or inhibiting Indonesian lawyers, well, acting for any lawyer to come into existence. There wasn't really a legal justice system that was really effective. And that period that lasted, according to these professors, to 98, and said, well, then we entered a new period, and the first report stopped in 98, and the state said, oh, that's nice, 98 plus 5 years is from 2003, and you're still too late. And so we conducted a new report, and that fulfilled the period to, it was kind of artificial, to 2008 when we sued them. But in one way or another, the court didn't enter into this matter. They didn't really follow the criteria exhaustively. They just said the state had no reason to invoke the statute of limitation. They're too guilty. The evidence is still there. And also another argument we invoked that was a bit of apart from these criteria was that we're still working on compensation claims for Jewish relatives from the Second World War. Compensation claims are still accepted from all those who suffered during the Second World War in Western Europe, and the state has said for these people, and there are many, we're talking about millions and millions of compensation awards, and they said to these people it would be formalistic and cold and unfair to confront you with statute of limitations. And we said, hey, what are you doing? So you're excluding this group and you're, incorporating this group. This is also racism, because if we really go by all the differences between these claims, the real difference is just the different ethnicity. It wasn't a nice argument to make, but we had to. And the courts accepted it and said, they didn't use the same wording as we did, but they said clearly the state has not closed its period in the 40s, because it's still working on compensation claims in, well, not similar cases, but similar in the sense that they date back to the same period. So we can't see that for this group you say, well, this is all closed, this is a long time ago, this is history.
Thank you. My name is Prof. I'm a lawyer. One of the interesting issue in this case is about the limitation period, or the issue of the expired issue. My question is it a new precedent in the Netherlands about the expired issue, or is there any similar case that gives similar ruling on the expired issue? Why I raise this question because I think in Indonesia, if you bring this case, the issue of the expiration is very, very important, because there are so many human rights violation, past human rights violation in Indonesia that have similar problems. in this case, one of the good thing is that the state has acknowledged that the fact itself was unlawful, and if we can get the similar acknowledgement from the government in Indonesia for other cases, for example. So the question is still the limitation of period.
Yep.
Yeah. Well, we've been discussing over the last days how you would deal with the situation here, since there's so many people involved, so many victims, and whether a court procedure is appropriate, is a proper answer to such a large number of victims. But this is also true for our country and the number of victims they made here. I mean, we now represent 9, and I mean, you can multiply this number with, I think, thousands in order to have the exact numbers of victims that we made here. So, I'm a bit, not direct answer to your question, but it occurred to me when you raised this and when you're considering bringing similar cases here, how you would approach the matter. What we did is try to limit the number of people that present a claim and limit the case, so not to start with, with everything at the same time and not include other islands and not to represent 100 people. Keep it simple. In a court that doesn't understand or feels that doesn't grasp the matter will reject it. I mean, you need to draw them in your imperiums, I say, to convince them really. Also here, I would think that the best way to go about is to start with a case that is as little disputed as possible in terms of facts. There must be easy cases. Don't take military cases. Don't take cases where people who were slaughtered were wearing arms. Just stick to clear civilian cases. Stick to cases that got international attention, perhaps, and international condemnation. So where you have support of others, who can also write reports on it. International human rights institutes that can present amicus curiae to the court, and thereby preventing that the court can deal with it in its small world, but exposing it to more wider attention, either from the human rights world or from the international world at large. So a clear abuse on behalf of a few civilians, if it occurred during armed conflict or during, if not an armed conflict, other individuals who suffered like torture. I mean, torture cases normally make easy cases if the evidence is available. And so make sure that the people who experience it are still alive and that the evidence is written down also in official reports, either from an external human rights commission or an internal, or by the government, which may not be widely available. So that's, and I mean, there are also, for example, easy cases, also disappearance cases, because the statute of limitation doesn't apply to disappearance. We have 2 disappearances from Rawa Gede, where the people, just were taken away and never turned up again. And disappearance, by definition, can't expire because the crime has not been solved. The person is still gone, and there's the crime of disappearance incorporates a duty to provide information on the disappeared person, and as long as this information is not provided, it's an ongoing tort. So you'll never be confronted then with the set of limitation. That is also quite an interesting. We filed a complaint against the father of our Queen-to-be, Mr. Rawa Gede. He's the former Minister of Agriculture in Argentina, and we believe that in his position he's responsible for 13,000 deaths in Argentina between 1976 and 2003. We filed, 83. We filed a criminal complaint early 2000s, and we were denied that complaint because they have all become time-barred. But now, there's a different law applicable in the Netherlands based on the United Nations Convention on Forced Disappearances, which makes disappearance a crime and also under our statute of criminal law. And so we refiled a complaint 2-3 months ago, saying that Mr. Gede can actually still be prosecuted on the basis of forced disappearance, and he bears information of all these disappeared persons. Have they been thrown into the rivers and the sea? Where are these persons? And we represent a few Argentine refugees living in the Netherlands whose parents have disappeared and are still missing. So that's also a way to go about it. It's kind of creative working with the... as to precedents in the Netherlands, the only precedent we have is the asbest case that I talked to you about. So the victims, this is just an ordinary employer-employee case. Employer that makes his staff working with asbest, and they inhale it, and they die. I mean, most people die then after 30 years or so long after time bars or the time to bring a civil lawsuit has expired. And then what said that when you're not aware of the wrongful act at the time, it's not acceptable that time bars start running from the time. They only start running from the time you have become aware of your illness. And then it's a 5-year period, so then you have to act fast. That's the only precedent, otherwise there are no precedents. But if there would have been a dispute about the facts, if the state would have said, listen, we don't know what happened, we threw away all the files, there's no duty for the state to keep the files, really, we can't conduct this dispute until we know that different, then it would be all finished.
My name is Arjo. I happen to be the coach of Philips CJS competition. You're aware that it's a simulated world court competitions held in Washington DC. The competitions case this year is exactly similar to this. So my point was, since I studied international law, is it possible that the legal avenue for this claim, except Indonesia, that I understand of, there are 3, right? The International Court of Justice. Indonesia brings a claim on behalf of a citizen through diplomatic protection before the International Court of Justice. Second, before the Indonesian court, although there will be argument of foreign sovereign immunity of the Netherlands. And the third possible forum, and this is the center of my question, except asking you 3 of these legal avenues. Is it possible to bring this case before European Court of Human Rights?
This case?
Yes.
The Rawa Gede case?
Rawa Gede case. European Court of Human Rights, that's the center of the argument perhaps is that the Dutch, because the torture, as you mentioned, one of the facts revealed that it fulfills enforced disappearance or torture under the United Nations Convention Against Torture, and I suppose that is incorporated in the European Charter of Human Rights. Can we argue somehow in the principle that it applies even to the event in the past based on the Vienna Convention of Law Treaties before ECHR? ECHR article, if I'm not mistaken, 64. Right? Whatever treaty that is applicable at the time when G-spoken norm, such as prohibition of torture, occurred, pierces or wins again that a treaty. That is an analogy to say that perhaps because the violation is so grave that retroactive, the principle doesn't apply. I mean, what do you think about 3 possible legal avenues? And my concern is more to European Court of Human Rights.
Yeah. The second, I'm not sure I got the second, but the first, the ICJ, I mean Indonesia, sued the Netherlands for the International Court of Justice.
Yes.
And international law doesn't know any limitation rules, interestingly enough.
Yeah.
Never understood, but I haven't been able to find any, and no one has ever invoked a set of limitation argument in an international dispute. So that would certainly be, interesting. And now the case is before the ICJ between Italy and Germany, where Italy granted individual claims against Germany based on the Second World War. So that case that very much turns around the immunity of Germany before Italian courts. So I'm not sure that whether the argument implementation will play a role there, but I would say yes, it could be done, but it will never happen for political reasons. I mean, ICJ is just rarely used, and most of the time for technical matters. It's now getting more and more involved in human rights issues, but you need to convince 2 states to use the avenue, and then most importantly, you need to convince Indonesia to use it against the Netherlands. I would welcome it.
But
It wants a cover all cases.
Okay.
And the second point was
bringing it before Indonesian court.
Against whom?
Against Netherlands.
But the Netherlands would be immune from. That's the case. Germany, Italy.
In several cases, like Al-Sani before the Court of Human Rights, the issue has been pretty controversial. This was a ruling 8-9 judges, where the 8-9 judges.
Al-Sani. It's true.
It was agreed, right, that foreign sovereignty cannot stand before gross violation of human rights.
I wish you could love. I'm afraid it's not working. No, I mean, someone has to do it, and at some point, maybe immunity will not be accepted any longer. But I wouldn't do it personally. We've never sued a state. We try to sue former officers. So then, but these are of course not alive anymore. So that's difficult in these cases. What rests, what is left, is only the states. Well, we sued the Netherlands in our courts. And that should be used by you. So you could bring any case against the Netherlands in our courts. Just bring these cases. Find a Dutch lawyer and bring these cases. Then you have no immunity at least. Or you do it simultaneously. You bring it here, you bring it over there. That could be done. The ECHR, we use the ECHR a lot in our pleadings. The defendant's argument has been that ECHR went into force in 54, and the wrongful acts were committed in 47. So at the time, the treaty was not applicable. Now, the European Court of Human Rights has not affected retroactive effect of the treaty. It has only accepted that crimes torts that have not been solved at the time that the treaty entered into force, then the treaty is still relevant to these acts. So let's say there's a duty to prosecute, if the state fails to prosecute, and it still hasn't prosecuted in 54, and it still can prosecute, then the treaty may apply to the failure to fulfill that specific duty. And that's how we used it. We said, well, actually, they pushed the whole thing under the carpet, and they still did in 54, and there was still, an opportunity to deal with it. It was used particularly for the failure to prosecute, the tort that we argued based on failure to prosecute. And it was still possible in 54. We also used the first protocol, Article 1, which states the right to property. And we said, since you're compensating the relatives of the Second World War victims, but you're not compensating the people from Rawa Gede, you're actually violating the prohibition of discrimination based on the right to property. So it was kind of difficult construction, saying that the convention prohibits discrimination linked to the property argument, which compensation, the right to compensation is of course it's a property matter. Compensation is property. I mean, it's not a gift. It's 20,000 euros. It's property of the people. So we argued also under that rule. And then, of course, normally the biggest challenge of the European Convention is the jurisdiction provision, whether the Dutch were under Dutch jurisdiction, acting on Dutch jurisdiction in Indonesia at the time. But since they argued it's still a colony, they really didn't challenge this one.
So, if I may summarize the last part in the European Court of Human Rights, the hurdle will be one, that that it is difficult to construct property arguments and permission to. What was the
our argument or the defendant's argument?
The possibility of bringing it before ECHR, and what will the hurdle be?
Well, first, there's a duty to prosecute under Article 2, the right to life and prohibition of torture. It incorporates a duty to prosecute, and that duty still existed by the time the convention entered into force, and that duty was violated. That was the first part. But in any case, the court dismissed our claims on the duty to prosecute because they say they have become time barred of the Dutch law. So we didn't deal with it. And second, we said they discriminated against Indonesian people because they didn't allow them their property, while they did deal with provide or protect the property of people in a similar period of time, the same period of time.
Which is the Jewish example.
Yes, yes.
And those claims will be difficult to be posed in ECHR.
Sorry, those claims were?
These claims, two of these grounds, discrimination and duty to prosecute, will that be difficult to be argued before ECHR?
No, ECHR, no. These are typical ECHR arguments. They're derived from the case law of the ECHR. Yeah. One of my concerns is that the decision of the court should be translated in the Indonesian language. I mean, if you ever want to use it here, you need an official translator copy of the decision, not just English. We try to do it when we lack the money, and translating it to English is much cheaper in our country than translating it to Indonesian, so we weren't able to do it. It's really an interest.